Rui, good morning to you. I mean, always complicated when it comes to unpacking judgments around RICA, but what I imagine is going to worry a lot of people when we start hearing the words surveillance and it's not being done properly. In a nutshell, and if you can speak Gareth for me, what does this actually mean?
Well, good morning to you, Gareth, and to your viewers, and thank you for having us. And you are quite right. I think as soon as we start discussing surveillance, our antennas stick up and it becomes a huge point of debate. So I think as a starting point, it's important to note that the Regulation of Interception of Communications and Provision of Communication-Related Information Act, which is quite a mouthful, which we commonly refer to as RICA, is South Africa's legislation which provides for the interception of communications of any persons by authorised officials of the state, subject to certain prescribed conditions. Now, the important thing to note here, Gareth, for everybody in South Africa, is that the entirety of RICA is not unconstitutional. It is only the provisions of RICA, which the Constitutional Court dealt with, that they have confirmed to be unconstitutional, that will be unconstitutional. Accordingly, for the remaining provisions, those will continue to operate as normal. Now, as you indicated previously, Gareth, this is a confirmation by the Constitutional Court of the High Court decision regarding the unconstitutionality of the provisions of RICA. And they ruled that those provisions were unconstitutional to the extent that they failed to provide adequate safeguards to protect the rights to privacy, and that also impinged upon the rights to access to courts, freedom of media and expression, as well as legal privilege as it pertains to legal practitioners. Now, Gareth, I think the important thing to note here is that this decision is a groundbreaking one which seeks to emphasize two things to South Africans. And the first is that within South Africa's constitutional and robust democratic society, we have working mechanisms to challenge state action and legislation that is unreasonable and unjustifiable, and have those set aside. The second point that is also extremely important is that the courts, or our judiciary, is extremely mindful of the important role that they play within society in maintaining an oversight function in relation to state action. Now, this decision, in a nutshell, essentially hits at the heart of a balancing exercise that needs to take place between justifiable intrusion upon one's personal life, and this is being in instances where the state is required to achieve some sort of justifiable objective, being maintaining state security or assisting with prosecutions or the like, and balancing that with unjustifiable or unreasonable intrusion upon one's personal life. Now, as you rightly pointed out, the failure to have the adequate safeguards to protect the individuals in relation to surveillance resulted in it falling part of the latter. In other words, that there was unjustifiable or unreasonable intrusion, or the potential thereof, into one's personal life. So in a nutshell, and we will get into a little bit of that in a few moments, but the order of unconstitutionality has been suspended for a period of 3 years, and this is in order to allow Parliament adequate time to go back to the drawing board to legislate the adequate safeguards that are necessary.
Rui, sorry, forgive me. Let me just jump in here. Sorry, forgive me, because I'm sure this is all very constitutional and it's very legal heavy, and I do appreciate you explaining that as far as the legal side is concerned. As you and I sit here today, what does this mean for me? Has my WhatsApp messages been hacked? Has someone been reading my emails? Help me and viewers understand that. Is that the kind of level we're talking about briefly?
So the level we're talking about, Gareth, here is mass surveillance or bulk surveillance, which the Constitutional Court has held to be unconstitutional. The second thing that they've said is that there was never any provision that allowed for someone who's going to be subjected to state surveillance to actually be notified at any point in time. The Constitutional Court has now addressed this. With regards to journalists and legal practitioners who are being subjected to state surveillance, what this now means is that the Constitutional Court has read in appropriate safeguards to ensure that the judge who issues the direction to allow for surveillance to take place may only do so where it's actually necessary, and it may impose other conditions. So what we're seeing here, Gareth, in the upshot of this, is that the public is actually being protected and safeguarded to a large extent when it comes to surveillance. And the Constitutional Court has narrowed the scope by which state surveillance can take place.
And when does this all need to come into play? I know you mentioned that it needs to go back to Parliament. You mentioned the length of 3 years. Rui, is this taking effect immediately, or does this now need to go through that whole process? Final brief question to you.
So that is a brilliant point, Gareth. So the order has been suspended of unconstitutionality for 3 years. but the Constitutional Court has read in certain sections into RICA which take immediate effect to provide immediate relief for this issue that the Constitutional Court has dealt with. So those would need to be abided by immediately.
All right. I appreciate your time in clarifying that for us. As I said, whenever we mention RICA and surveillance, it always becomes a very complicated discussion. And Rui, I'm sure we'll unpack that in more detail as we get to grips with this. Rui Lopes, Managing Director of Lopes Attorneys, speaking to us about surveillance and RICA this morning here on eNCA.